This is an interview organized by Organization for Defending Victims of Violence, the so-called ODVV. Our special guest is Professor William Schabas, which is a Canadian academic specializing in international criminal law and international human rights law. He's a professor of international law at Middlesex University in the United Kingdom, professor of international human rights law and international criminal law at Leiden University in the Netherlands, an internationally respected expert on human rights, law of genocide, and international law. Many of international criminal law experts started learning this field, in my viewpoint, by his very precious books, especially Introduction to the ICC, Genocide in International Law, and in particular, the more than 1,000-page commentary on the Rome Statute of the International Criminal Court. I am extremely honored and excited that I am going to take the advantage of the presence of the esteemed Professor of International Law, William Schabas, today, and to learn personally from this conversation. If you have a beginning word, dear Professor, please feel free, and then I start to ask you questions.
Okay, well, just to say that I'm happy doing this, and it's nice to see you in person, and I'm awaiting your questions.
Thank you very much. So let me begin with the first question. As you're well aware, dear Professor, Hamas announced the start of what it called Operation Al-Aqsa Flood, stating that it had fired over 5,000 rockets from the Gaza Strip into Israel within a span of 20 minutes. The question is how and if any, to what extent Israel entitled to resort to self-defense? Would the previous status of the land as occupied make any difference to the answer?
Well, I'm not sure I understand your question entirely, but I don't think there's any doubt that Israel has a right under the Charter of the United Nations and under customary international law to act in self-defense. To me, the question is the proportionality of the self-defense. So self-defense takes many forms, and self-defense primarily is a matter of taking action to protect yourself. One of the things that we don't know about the conflict, at least that I don't know, and I haven't found information, is the extent to which the rockets fired by Hamas resulted in casualties. I know that in the past, Hamas was firing rockets and has been doing so for many years, but the casualties were very, very minimal, actually. These were not very sophisticated weapons, and they were not targeted. That was one of the criticisms of them under international law. So I don't know the extent to which that is, how much damage was done, because Israel does apparently have very effective systems for protecting itself against rockets. But certainly it's a state and it has a right to act in self-defense.
My last part of the question, dear Professor, was related to this fact that according to many United Nations Security Council resolutions, the 1967 territories have been occupied illegally under international law. So would this status of the occupied territories prevent Israel from having the right to self-defense? This was the last part of my question.
Well, I don't understand that argument. If Israel is attacked, missiles were fired at Israel into its territory, and it has a right to defend itself from that.
Thank you. The second question, Professor, is there any practical solution to accelerate the process of investigation in the situation in Palestine before the International Criminal Court, in your viewpoint?
Well, the International Criminal Court has an open investigation into the situation in Palestine. It doesn't actually have jurisdiction over the territory of Israel, except to the extent that crimes may have been committed on the territory of Israel by nationals of a state party, and Palestine is a state party. So the actions of Palestinians inside Israel are probably subject to the jurisdiction of the court. But this all depends on the willingness of the prosecutor to pursue a proper investigation. And so far, the prosecutor has shown little enthusiasm for investigating the situation in Palestine. He inherited it from his predecessor, who had moved slowly, but with a certain amount of deliberation towards developing an investigation into Palestine, into crimes. Essentially, then the concern was with the crimes committed on the territory of Palestine, where Israelis arguably were the perpetrators, including the development of settlements and the moving of settlers into the West Bank. So really this leaves everything to the initiative of the prosecutor. And as I say, he's not been keen on doing this. The prosecutor has, in the last year and a half to 2 years now, really largely focused the efforts of the court on the investigation into Ukraine. Yes. And these are determinations that have a political dimension to them. So we shall see. It's difficult to know what's going on in the mind of the prosecutor. The model of the Rome Statute leaves these things entirely at the discretion of the prosecutor. They're not. He doesn't have to go before a committee and justify them. He's got an open investigation, so he can decide to make that the focus of his efforts, and he can decide to ignore it. And I don't know what he's going to do.
Thank you very much. My third question concerns the capacities of domestic courts, dear Professor. How domestic courts, in your viewpoint, may be of investigative or prosecutive role in regard to the crimes committed in Gaza by Israel? Is the admissibility here still a challenge?
You know, the Rome Statute creates a presumption in favor of domestic prosecution and says that it's the duty of states to prosecute these crimes. I don't think that it's realistic to expect that we're going to have proper prosecutions inside Israel unless Israel is able to capture suspects and prove that they committed crimes. We'll see if that happens. They may do that. I don't know enough about the functioning, the ability of the Palestinian justice system to hold trials. It's always theoretically possible that third states could exercise universal jurisdiction to the extent that war crimes are being committed, for example, or other international crimes. But right now, I think this is all theoretical at this point.
There is an argument also put forward by Israel that Hamas is using protected properties for military use so they can target places such as hospitals. Is this a proper argument legally and also based on the facts?
Well, if Hamas is using civilians as human shields, or if they're using civilian objects in order to conduct military activities, this would be a violation by Hamas of international humanitarian law, and it would be punishable. It doesn't give Israel any additional pretext to go and attack those places. But if a civilian object in Gaza, like a hospital, is being used for military purposes, then it loses its protection as a civilian object. It's protection from attack, and it becomes a lawful military objective. Israel still, of course, subject to rules of proportionality and minimizing damage to non-combatants. So it's not a license to Israel to attack a hospital merely because Hamas may be using it for a military objective, but it certainly means that the hospital loses its protection as a civilian object.
Thank you very much for your comprehensive answer. The fifth question, Professor, is that can and how human rights bodies of the United Nations especially be of any involvement in addressing criminal conducts committed in the war?
Well, human rights bodies through the United Nations have increasingly, in recent years, tried to take positions about criminal conduct. So the human rights reports that are prepared by the Human Rights Council now almost typically reach conclusions about whether war crimes, crimes against humanity, even genocide, are being committed. I think it's a very legitimate question as to whether this is really very helpful. We have justice institutions, courts, including the International Criminal Court, whose job it is to make those assessments. And I think that in in the past, the human rights mechanisms may have been tempted to do so because there was a lack of criminal justice institutions capable of doing it. But they make very how should I say, determinations that crimes are being committed in a very vague and cautious manner. So they say things like, there is some evidence that were it to be believed by a court of law might lead to a conviction for crimes against humanity or genocide. This is a pretty light touch, and maybe it's better for them simply to stick to the allegations about international human rights violations.
My sixth question concerns this fact. As you're well aware, dear Professor William Schabas, four resolutions recently were all vetoed, two of which proposed by Russia, one by Brazil, and one and two and also one by the United States of America. However, a resolution proposed by Jordan, an Arab group of nations in the General Assembly, was ratified by 120 yes votes, 14 no votes, and 45 abstentions. First of all, do you think the United Nations Security Council shall be criticized for not being able to end the war? In case, is there any practical solution, United Nations Security Council, for the UNSC to adopt a resolution to restore the security to the region? And secondly, given the non-binding nature of the United Nations General Assembly resolutions, what complications could the adopted resolution may have indeed?
Well, that's a very complicated question that involves a lot of issues about international organizations and their abilities. We make this distinction between the binding nature of Security Council resolutions and the non-binding nature of General Assembly resolutions. I think maybe that's too sharp a line to draw. There are Security Council resolutions that are not respected, and nothing happens when they're not respected, just as there are General Assembly resolutions that reflect a broad consensus, broad support for a certain view of major world issues, and that are very important and very significant. So, one could be more, you could make that distinction more important maybe than it really is. The Security Council obviously has great difficulty when the vital interests of permanent members of the council are engaged because of the veto, and that was the agreement in 1945, and nothing short of ripping up the peace agreement of 1945 in the Charter of the United Nations is really going to solve that problem, I think. But it's clear that there's broad support for an end to this conflict, a peaceful end to the conflict, and finding the language that the world can agree to on how to deal with the conflict in the Middle East is a very difficult enterprise, because the views are so varied about how to deal with it. To me, it's obvious that the way forward is to have an independent Palestinian state, and when you have an independent Palestinian state, then the region can settle down and the two peoples can learn to live with each other side by side. But I think the great concern and the great suspicion is that Israel's military activity in Gaza is going beyond self-defense, and that there's an agenda at work which aims to alter the demographic situation in Gaza, and to create an irrevocable situation that will just become a fact. We hear talk from people like Netanyahu about as if this is a second war of liberation like the one in the 1940s, and that's a very ominous suggestion, because it's about, in the 1940s, it was about driving people out of their homeland, out of their historic territory, in a way that they could never come back. I mean, that's how Gaza became what it is. It's because the ancestors of the people living in Gaza were driven out of their homes, and they were never allowed to move back to them.
And also, there is another question. According to many reliable reports, the blockade of Gaza resulted in the lack of electricity, fuel, powers for generators, among other things. The drinking water is running out, suffering hunger, put pressure over the civilian population, and no enough aid enters Gaza. Could this be regarded as a collective punishment, and whether it could be qualified as one or more crimes within the ICC's jurisdiction, and in particular genocide under Article 6 C of the Rome Statute?
Well, the deprivation of things that are essential for life in Gaza look as if they are not. This is not justified by self-defense or by military necessity, and so it suggests that this is, in effect, as you've said, a form of collective punishment. It's also I'd say, a warning sign or a danger signal that it might harbor some more brutal objective. And in order for it to be labeled as genocide, you have to prove that there was an intent to destroy the people. And that requires very, very clear evidence, unequivocal evidence. And I think this is a matter that I think all we can say at this point is that these are warning signs that should not be neglected or overlooked. And that when you ultimately, the whole world knows, it's just common sense that if you deprive people of fresh water and of food and of medicine for long enough, you will destroy them physically. You will exterminate them. And so there has to be it's a situation that cannot continue. And the longer it goes on, the stronger becomes the inference that there's actually an intent to destroy the people physically.
Can this intent be inferred from some statements by the official authorities of Israel and also military commanders saying, for example, Hamas should be destroyed or something like that?
There's been a lot of practice on this, as we call it. There are now many judicial determinations of genocide. And as a general rule, courts have not attached a great deal of importance to statements along those lines. People point to Hamas's charter or declaration where they talk about destroying Israel and suggest the same thing. I think that my reading of the legal authorities on this is that those types of statements don't make a big contribution to drawing the inference that the intent is to physically exterminate the population.
The World Health Organization, WHO, has confirmed that 23 hospitals in northern Gaza and Gaza City have received repeated orders to evacuate. Is this permitted under international humanitarian law? Similar to this, the Israel Defense Forces, IDF, on Friday, October 13th, dropped leaflets from planes into Gaza, calling on residents to urgently leave their homes and move south. Earlier, IDF issued an order to around 1.1 million Gazans to flee from the north of the Palestinian territory within 24 hours. Could this order be regarded as forced displacement, or it should be qualified as a precautionary measure taken by Israel?
When we talk about forced displacement in the Rome Statute, we talk about coercive measures that are taken. I think that what Israel will say is that they're not forcing people to leave. They're just warning them to get out of harm's way because of this is going to be a military zone, and that they're likely to get killed or injured if they remain there. So, Israel will justify this, claiming that it's a humanitarian objective. The question then, of course, as you say, these are hospitals and sometimes it's impossible to evacuate them. Well, let's be generous to them if that they are trying to focus their fire on military objectives, which is good practice anyway. But I think the counter argument is that this is in effect creating a situation of coercion for the people of northern Gaza. That means they have to evacuate the territory altogether, and their fear. And again, this goes back to the history of the Palestinian people on the territory, that if you abandon the territory and leave it, that you'll never get back. And I think I think everybody, the whole world, should be able to understand why people might feel that way.
Thank you very much. And the last question, the former special rapporteur of the United Nations on OPT, Mr. Michael Link, has expressly used the term apartheid for the conduct of Israel during the entire occupation period. This term has also been repeatedly used by subsequent rapporteur, Ms. Albanese, and various NGOs such as Amnesty International. What do you think in this regard?
Well, the definition of apartheid, which of course we inherit from the situation in Southern Africa, particularly in South Africa, from going back to the 1940s, is a regime of official segregation based on race, ethnicity, and so on. And this is something that we see in both in the occupied West Bank and within Israel itself. And so it's a very appears to be a very legitimate use of the word. It's a controversial one. It's one that people find very provocative, but there's a lot of authority for it, and major NGOs and major authorities that you've just referred to have also used the term. So I don't have any great problem with using it.
Thank you very much, dear Professor Schabas, for your time. It was a really great honor for me to host you in this very important session on the recent conflict in Gaza and related international criminal law analysis of the situation. Thank you very much.
Okay, my pleasure. Bye-bye.
Have a good day. Bye-bye.